Good morning. Thank you so much for joining us today for our Wednesday webinar. Today, we are going to be talking about Social Security disability for cystic fibrosis. Before we go any further, I want to give my typical warning, which is that this webinar is not meant to be legal advice, but is instead meant to serve as additional educational material surrounding Social Security disability claims for cystic fibrosis. To that end, I do not take questions on the live webinar, and I do not really respond to questions on the replay and the comments. And the reason for that is not because I don't want to help, but it's because we typically need more information to give a good, solid, reliable answer. And so for that reason, the best way to ask your questions is by scheduling a call with us, sending us an email, or giving us a call directly. That way we can take the time, we can get the information we need from you in a private setting. And if we are able to help you. And if we are not able to help for some reason, try to point you in the right direction to get you someone who can help. So with that being out of the way, let's go ahead and get started. Here is our roadmap for today. Today, we are going to start out by talking about some Social Security disability basics, some guidance from the Social Security Administration, one of the potential listings that might be in play for cystic fibrosis. And as you will see, there are actually several ways to meet the listing. So it's not just, it is one listing, 3.04, but there are several subparts that you may be able to fall under and qualify through the listing. Additional considerations to make, and then finally, of course, how an attorney might be able to help you with your Social Security disability claim. Before we get started, a little bit about me. My name is Caitlin Wildoner. I am the founding attorney of Beacon Disability PLLC, which is a law firm based in Florida where we exclusively practice federal administrative law, and we help clients with their Social Security disability cases from the initial application through the appeals counsel level. So if you have a question, please feel free to reach out to us. Again, if for some reason we cannot help you, we do try to put you in touch with somebody who can. Okay, Social Security disability basics. There are two different Social Security disability programs. There's Social Security Disability Insurance, or SSDI benefits, and then there's Supplemental Security Income, or SSI benefits. Both programs are going to require that you be disabled and unable to work for at least 12 months. That doesn't mean that you have to be disabled and unable to work for a year before you apply. It just means that there is no such thing really as temporary disability. So the Social Security Administration is going to want to make sure that you either have already been disabled and unable to work for 12 months, or if you haven't hit that 12-mark month, that it's likely that you're going to be disabled and unable to work for at least 12 months. The other thing is if your condition is expected to end in death. That is the only way kind of around that 12-month duration requirement, is if you are looking at a lifespan of only a few months, then that's where that can kind of also change a little bit. Where the programs differ, so they both require that you be disabled and unable to work for a period of at least 12 months or have a condition that's expected to end in death. Where they differ is with SSDI benefits, you have to have a sufficient number of work credits. Typically, we say that you have to have worked 5 of the last 10 years in order to have enough quarters of coverage to qualify for SSDI benefits. You can actually go online to your My Social Security account to see if you have the sufficient number of credits. If you do, it should show kind of an estimated amount for what your SSDI benefits would be. So that's one thing that you can do to make sure if you kind of aren't positive if you worked 5 of the last 10 years, that's usually what I'll recommend people do, is that they log into their My Social Security account to look to see, do you have a sufficient number of work credits? While you're in there, you can also look at your earnings history that Social Security has for you and make sure that it's accurate, that it matches up with what it should be. So that's SSDI. Those are two things you can do inside the My Social Security account related to SSDI. With SSI benefits, it doesn't have the work history requirement, but it does have income and asset restrictions. So with SSI, you cannot qualify if you have above a certain number of assets and income coming into the house. So income is a little bit more of a flexible area in a way. It still has very bright line rules about what they are, but it changes. It depends on how many people are in the household, how many children you have, things like that. The assets are the same, no matter what, no matter how many children you have. If you're single, the assets are $2,000 in assets. If you have more than $2,000 in assets as a single person, you cannot qualify for SSI. If you are married and you have more than $3,000 in assets, you cannot qualify for SSI. Okay. So it's just easier to say the asset rules. Income, there's still bright line rules that if you have above a certain income threshold and you have a certain number of people in your house, you can't qualify for SSI, but I don't cover that on the webinar just because there's too many possibilities, okay? But you can get information about that online on the Social Security Administration's website, what the income restrictions are. Okay, once you submit your application for SSDI or SSI benefits, what happens is first they'll make sure that you're you. So they usually will mail you an application. It's not a whole application. It's part of it. They want to review it and make sure it's accurate. So you'll sign it and send it back to them. Once they have that, they do kind of a step 0. Okay. The step 0 for each of the programs, SSDI and SSI, is different. And the step 0 is the second prong. So with SSDI, the step 0 is making sure that you have a sufficient number of work credits. If you don't have a sufficient number of work credits, they won't get to this 5-step evaluation process. They will send a pretty quick denial that says you do not qualify for Social Security disability benefits because you don't have enough work credits. Step 0 for SSI, similarly, is going to be making sure that you are below the income and asset thresholds. If you have too much income or too many assets, they won't get to the medical portion of the claim. They will say you do not qualify for SSI because you have too much income or too many assets. Okay. As long as you meet that step 0 for whichever program you applied for, they'll start moving into this 5-step evaluation process. This is kind of the medical portion of the claim that's kind of what I call it. They will first look to see, are you engaging in substantial gainful activity? Substantial gainful activity for 2023 is working 20 hours a week or more, or earning more than $1,470 a month in gross earnings. If you are doing either of those, and certainly if you are doing both, so if you are working more than 20 hours a week or earning more than $1,470 a month, you're engaging in substantial gainful activity. And by definition, the Social Security Administration will not be able to find that you are disabled. So you'll get a denial. If you are not engaging in substantial gainful activity, they will go to step 2. They will look at the medical records and they will determine, do you have at least one severe medically determinable impairment? So they'll look at the medical records looking for at least one severe impairment. And that means that you've got an impairment that does have an impact on your ability to perform work-related activities. If you don't have at least one severe impairment, they deny it at step 2. They say you don't have any severe impairments that are preventing you from working. Again, by our definition, you cannot be found disabled. As long as you have at least one severe impairment, they move to step 3. They look to see, do you meet or equal a listing? Again, we will talk about the cystic fibrosis listing in just a minute. As you will see, it's really hard to meet. So if you do meet or equal that listing, they'll approve you at step 3, you're good to go. If you don't meet or equal a listing, there's kind of a step 3B in there. One day I'll add step 0 and step 3B to my 5-step evaluation, but today is not that day. So step 3B is where the Social Security Administration will create a residual functional capacity for you, which is what they believe you are capable of doing based on your medical records. And so using that RFC, the residual functional capacity, they look to see, can you go back to do your past relevant work? Past relevant work is work that you've performed in the last 15 years, and you have to have performed it long enough to learn how to do the job. So if you did it for just a couple weeks and it is a highly skilled job, that's not going to be considered past relevant work. If you have done it for the entire 15 years, that job that you've done for the last 15 years is going to be your past relevant work. If you job hop and you go to a different job or a different workplace every 2 years, each of those may be considered past relevant work. So that's what they're going to look at, is they're going to look at your RFC and they're going to compare it and see, okay, can an individual with this RFC go back to do your past work? If you can go back to do your past work with your RFC, you'll get a denial. If you cannot go back to your past relevant work with your RFC, they look to step 5. Still using that RFC, they take into account the RFC, your age, your education, your past work, and any transferable skills that you may have gained. And they look to see, okay, you can't go back to your past work, but are there any other jobs that you can shift to? Can you engage in any other work that exists in the national economy? If you can, if there are other jobs that exist in the national economy that you can perform, then you will get a denial and they will say you can go perform these jobs that exist in the national economy. You are not disabled. If you cannot engage in any other work using your RFC, age, education, and past work experience, then you can get an approval at step 5. So step 3 and step 5 are really where you can ultimately get the approvals. As you'll see, the bar to meet the listing is set pretty high. Okay, you can still qualify for Social Security benefits if your RFC is less than what your past relevant work would require, and or the RFC prohibits you from engaging in substantial gainful activity on a regular and continuing basis. This can mean that you are unable to sustain competitive employment, which can mean that you are disabled under the Social Security Administration's rules and regulations. It can also mean that you meet one of the grid rules. The grid rules, we have done webinars on them before. I'm not sure if we've done any this year in 2023, but they are largely the same as last year. The grid rules themselves has not changed. Things that have changed we've already talked about in this webinar, like the substantial gainful activity levels and things like that. So if you are 50 to 55, 55 to 60, or 60 to 65, you may want to go back and watch one of those specific webinars because it may kind of give a little bit of extra insight as to what Social Security is looking at in step 5. Okay, so that's where the grid rules come into play, is really at step 5. All right, here's the listing. This is 3.04 listing A. Okay, so here, as you can see, it's going to look at your age, going to look at your height, and it's going to look at your, no, that's it, age and gender. I'm sorry, and gender. I knew there was something else I was missing. Age, gender, and height. So that's what they're looking at here. They will look to your FEV1 test results. And if you are less than or equal to the appropriate value in either table 7A or 7B, depending on your age, if you're between 18 and 20, 7A is your table. If you're older than 20, 20 or older, 7B is going to be your table. Okay, you want to go down, you'll follow the column, whether you're female or male, and then you will look to your height in inches or in centimeters, whichever one is easier for you to do. You'll follow and you'll find the square that is your FEV1 level has to be less than or equal to. Okay, so that's 3.04A. 3.04B is going to require exacerbations or complications that require 3 hospitalizations of any length within a 12-month period, at least 30 days apart. And that 12-month period has to occur within the period that they're considering in connection with your application or your continuing disability review. So just because you had 3 hospitalizations of a week each, 2 months apart, 4 years ago, is not relevant if that's the last time you had that hospitalization. You haven't had any hospitalizations since then, and you're either on an SSI only application where you just applied last month, so they're looking at last month to now, or if you've got a continuing disability review, okay? 3.04C is going to require a spontaneous pneumothorax secondary to the cystic fibrosis that requires a chest tube placement. 304D is going to require respiratory failure that requires invasive mechanical ventilation, non-invasive ventilation with BiPAP, or a combination of both. And that treatment has to last for at least 48 hours, or if after a procedure, 72 hours. So that's 3.04D. 3.04E would require pulmonary hemorrhage that requires vascular embolization to control the bleeding. 3.04F, you'll see the table over here. This is table 8. You've got to have pulse ox less than or equal to the percentage at your altitude. And that has to happen twice within a year and at least 30 days apart. Again, that year that it happens twice within has to be within the period that they're considering. So again, just because it happened 7 years ago does not mean we can use it today necessarily. And then as you'll see, G is kind of a catch-all in a way, where it's got 2 of the following 4 exacerbations or complications. You can have 2 of the same or 2 different within the 12-month period. Again, 12-month period has to be within the time frame that they're considering. And so as you can see there, there's 4 different exacerbations or complications typically connected with cystic fibrosis. And if you've got 2 of those within the 12-month period, and as you can see, there are time limits within each of those as well. The pulmonary exacerbation, so that you have to have 10 consecutive days of IV antibiotic treatment. So each of those is going to have their own timeline. A pulmonary hemorrhage is going to require hospitalization of any length. So even if you're only hospitalized for 24 hours, it's got to happen twice. And that doesn't have to happen twice, but you have to have 2 of these 4 happen within 12-month period. I hope that is clear. Okay, additional considerations. Medical records are paramount. So as you can see in each of these listings, one listing, but each of these components of the listing require medical records. So hospitalizations, chest tube placement, that's going to have an op report with it. Invasive mechanical ventilation, God, it's going to be in the hospital likely. Vascular embolization, hospitalization. Pulse ox test, medical records, likely potentially connected to a hospitalization. Exacerbations or complications. Some of these are specifically requiring hospitalization. 10 consecutive days of IV antibiotic treatment. So as you can see, medical records are critical. And it's not just, as I've mentioned before, it's not just can you go back to your past work, but are there any jobs that exist in the national economy? If you're over 50, the grid rules might apply. Functional capacity can also be relevant. If you don't meet or equal one of those listings that we just went through, but your functional capacity is such that you cannot go back to your past work or any other work in the national economy, then you can get a favorable decision. Objective medical records are important. As you can see in this listing, we've got test results. That's an objective medical result. You've got hospitalizations, chest tube placement, ventilation, vascular embolization, pulse ox tests, IV antibiotic treatment. All of these are objective medical records, okay? So they are very important when it comes to disability cases. Finally, how can an attorney help you? This is not a complete exhaustive list of what we do in our cases. It just provides some insight into what we can do. We do provide guidance on what correspondence from Social Security actually means. We can file necessary appeals. We review your medical records in your case file. We discuss what additional medical records might be helpful in your case. Going back to the listings again, the objective medical records. We're not going to tell you, okay, you've got to go be hospitalized because there's no way to control that. But if the additional records would be helpful, would be, for example, that op report from the chest tube placement, and you don't have it, and the hospital is not really giving it up easily, we talk about that with you. We say, look, we know you've got this. Unfortunately, we're having a hard time getting these records. Can you jump in and help us? So sometimes it's even that, not even creating additional records, and we don't falsify additional records ever. But what additional records might be helpful? What are we having a hard time getting? What is missing? If you went to this hospital and you're telling us that this happened while at the hospital, but it's not anywhere in the records, we point that out. We say, look, that's not in the records. How can we get those records? We can also review your documents for accuracy and completeness and discuss what Social Security is looking for in their requested forms. So you may know that we don't typically fill out the forms that Social Security sends you during the initial and reconsideration stages. And the reason for that is because my method is that they are kind of testimony without having to go before a judge. And so I always encourage clients to respond honestly. We don't sugarcoat things. We also don't over-exaggerate things. But we can share with you what Social Security is looking for. Why are they sending these forms out? and reviewing them for accuracy and completeness. If you've told us something and you're writing something totally different on the form, we'll see that and we'll say, hey, this doesn't quite match up. Did you mean something else? Did you misunderstand? Am I misunderstanding? And that way, if I can misunderstand, it's possible that Social Security can also misunderstand. So that's something that we do. We do work back and forth with you and Social Security to provide relevant updates throughout your claim. If you have to go to hearing, we prepare you for that hearing, and then we question you and any witnesses during that hearing. When I say witnesses, I don't typically mean your witnesses, like your family members and your friends. We tend to handle that type of witness testimony differently. But with Social Security hearings, there is almost always a vocational witness present, and there may also be a medical witness present. And so those are the witnesses that we do question. And of course, if there are other witnesses, we do prepare for those as well. As promised, here's our contact information. If you have questions, we will also put a link in the chat to schedule a call with us at a time convenient for you. Otherwise, you can give us a call, send us an email. We are always happy to help in any way that we can. And if for some reason we cannot help, we do try to put you in touch with someone who is able to. So with that, thank you so much for joining us today. Have a wonderful day.